Hello, everyone. Welcome back to the Legal Tea Podcast. I'm your host, Elaine Clarkson, and we are back with attorney Alexis Wilson. Today, we're going to be talking about the 6th, 14th, and the 8th Amendment rights. Attorney, to get us started, can you tell me what the 6th Amendment grants us?
Yes, the 6th Amendment grants us a list of rights: the right to counsel, the right to confront your accuser, the right to trial, the right to compulsory process, and also the right to view the lineup.
Can you also explain what is the right to counsel?
Yes. So the right to counsel is literally you have a right to have an attorney present at every step of the legal process. So if you go into arraignment or if you go on a trial, pre-trial, anything like that, you have a right to have an attorney there.
Can you also explain what it means to have the right to confront your accuser?
Yes. So you literally have a right to confront the person that's accusing you, the person that they say is seeing you do something, the person that they said that they saw you, somewhere. You literally have a right to confront that person that asks that person questions.
Can you also explain what does the right to a fair trial include?
Yeah. So the right to trial also includes a jury trial. It depends on the crime in the state of Louisiana. You can have a jury by 6, jury by 12, or you can have a judge trial. It also includes a right to speedy trial, which means either you or your attorney, if you filed it, it would be pro se. If your attorney filed it, it would be a motion for speedy trial. Once that motion is filed, at that point, you'll go for the judge. The judge will usually give you a closer trial date. That's just to get the process rolling, like literally a right to a speedy trial.
Can you also explain the right to compulsory process? Can you explain what that is?
Yes. So the right to compulsory process is literally a right to subpoena witnesses. You have a right to subpoena people that can come and testify on your behalf. You can just provide their names and their addresses to the clerk of court office. They'll send out the subpoena and they are compelled to come to court.
Okay, we're going to switch gears here and we're going to talk about some hypotheticals. So if a person were to be arrested and during that arresting, they start to confess to the police, what amendment protects them?
So it's the 14th Amendment that protects them.
Can you further explain what the 14th Amendment protects?
Yes. So the 14th Amendment protects the voluntariness of the confession. A confession has to be completely voluntary. You can't give a confession under duress. You can't give a confession if you're pressured or anything like that. If that do happen, or if you think that's happening, you can definitely get with your attorney to file a motion, whereas that confession cannot be used against you.
Can you also explain what protections does the 8th Amendment provide?
Yes. The 8th Amendment provides protection against cruel and unusual punishment and also excessive fines.
Okay. Another hypothetical. So when a person is in jail waiting for their first appearance, how are they able to get a lower bond?
So actually it happens after first appearance.
Okay.
So at first appearance, the judge will set a bond. If the bond is too high, either you or your attorney can file a bond reduction, file for a bond reduction, and the judge will usually take in consideration some facts. You'll hear argument from the prosecution and argument from the defense. And it would make a decision if your bond is going to be reduced or not.
Okay. Lastly, what can a person do if they are waiting what can they do to get out of jail if they have not been formally charged yet?
Right. So either if you do it, it's pro se. If your attorney do it, they just file it. It's called a writ of habeas corpus. When they file a writ of habeas corpus in the state of Louisiana, the DA's office has a certain amount of days to institute prosecution for a felony or institute prosecution for a misdemeanor. If it's coming up upon those days and that hasn't been done, which means they haven't formally charged the person yet with a bill of information, they can file a writ of habeas corpus. At the time that the writ of habeas corpus is had for a hearing, it's usually within 72 hours. If the person is formally charged, at that point it will render the habeas corpus moot. And then they go forward in the process with arraignment and trial and all that good stuff. But if they do have not filed that bill of information and prosecution has not been instituted, at that time they're usually relieved of their bond obligation and they're usually let out of jail.
Well, thank you so much for that, Attorney Wilson. Thank you for answering my questions regarding the 6th, 14th, and 8th Amendment rights. And thank you guys for tuning into the Legal Tea Podcast. I'm your host, Elaine Clarkson. Until next time.